Good morning, everyone. It's a wonderful Sunday morning in Delhi. Thank you for coming to the day-long event. The day consists of a book release, signing of the MOU between Cornell University and Jindal Global University, followed by a discussion around the book and a conference, and ends with a Human Rights Day lecture. I'd like to take this opportunity to call upon our Vice Chancellor, Professor Dr. C. Rajkumar, to begin the proceedings.
Thank you, Vishwas. First of all, a very good morning to all of you, and it's a very special moment for us today as we are doing this book launch and indeed the conference. It's also the Human Rights Day. It's a day that marks the collective struggles of humanity to address issues relating to equality, discrimination, as well as many aspects of the evolution of human society. And for all of us to assemble here to celebrate Human Rights Day, but also to recognize the huge challenges and the gap between the rhetoric of rights and the reality of rights is also a significant contribution that academic institutions such as Cornell University, Cornell Law School, and OP Jindal Global University and Jindal Global Law School can undertake. As Vishwas mentioned, it's also a very special moment for us today as we undertake the launch of a book entitled Women's Human Rights and Migration, Sex Selection Abortion Laws in the United States and India, written by Professor Sital Kalantry of Cornell Law School. I have not had the opportunity to read the book, but I have known Sital for a long time and I am familiar with her academic and research work. In fact, this event here that we're hosting today is in many ways a sequel to a larger conference that we had undertaken together, and that event marked the occasion of the beginning of the collaboration between Jindal Global Law School and Cornell Law School, beginning of our discovery of the scholarly and academic contribution of Professor Sital Kalantry. And of course, that event also had witnessed the distinguished presence of Honorable Ms.Justice Gita Mittal. I also want to take a moment to welcome Honorable Ms.Justice Gita Mittal, the Acting Chief Justice of the Delhi High Court, for her presence here. All I can say is that there are very few people in this country who have had profound impact on the evolution of law, interpretation of law, and indeed having the far-sighted and jurisprudential knowledge and perspectives that can help the transformation of law and jurisprudence. And Justice Gita Mittal is one such person. Beyond her contribution to the evolution of law on a range of areas, she is deeply committed to academic engagement, and we are very fortunate that we've had the privilege of hosting her both at our campus as well as here in Delhi for a number of conferences. She has never said no to us, and that reflects her strong commitment to academia and academic institutions and the growth and evolution of research in academic institutions. I also want to take a moment to thank my two colleagues who put together this conference, Professor Saptarishi Mandal and Professor Vishwas Deveya. Both of them have worked tirelessly in the last several months to put together a few amazing panels as well as a Human Rights Day lecture in the course of the day. I'm also very delighted to see all of you, our students, and as well as faculty members who have chosen to be here on a Sunday morning, particularly when the semester has ended and you could be doing so many things. I know many of you are doing your internships. Some of you have traveled from other cities in India to be part of this conference. I can only say that it's going to be absolutely worth it. When we were students, and both Justice Mittal and I were in Delhi University Faculty of Law, events like this could happen typically in once in your entire academic studies at our law school. for us at Jindal, it's a privilege that we've been able to host a conference of this magnitude with so many outstanding scholars and practitioners speaking and reflecting about various issues that are germane to the theme of the book and indeed the theme of the conference, which is upholding women's human rights, transnational dialogue on gender bias, sex selection. This conference is organized in the larger backdrop of many issues that have come to the forefront regarding gender in society, and this is a reflection of the more stronger commitment of Jindal Global Law School and OP Jindal Global University in addressing some of these issues at a public discourse level. I also want to take a moment to reflect about the strong relationship that OP Jindal Global University and and Cornell University, and in particular the Cornell Law School and Jindal Global Law School have evolved over the years. There again, Professor Sital Kalantry has been the architect of it many years ago, to be precise, in the year 2008 when we were, and 2009 when we were beginning to evolve as an institution. Professor Kalantry discovered us and engaged with us to begin a dialogue, a relationship, and that was nurtured over the years, and that has now culminated in many forms of relationship over the years, including student exchange program, faculty visits at both end, joint conferences, as well as joint teaching. Sital also was a Fulbright scholar and taught courses along with our faculty. We have had joint clinical programs along with Jindal and Cornell students working together, which also culminated in a publication. And this relationship, which has evolved in the last several years, has today reached its pinnacle, in the sense that what we are going to do today is that we are going to sign a memorandum of understanding which will enable students to be able to pursue a dual degree program at Cornell Law School. It is the first of its kind anywhere in Asia and Africa for having a relationship of this kind. Cornell itself has had no such relationship in the whole of Asia and Africa. The only such relationship has been with European institutions, and so we are very delighted that this MOU that we will be signing will create opportunities for Jindal students to pursue a dual degree program at Cornell, and also provide other academic and research opportunities for both faculty and students. I also want to take a moment to recognize the importance of academic discourses such as this. I think there is a larger responsibility that academic institutions need to have, and this responsibility is based upon the need for dialogue, deliberation, as well as democracy in all what academic institutions do. And one of the things that academic institutions are best at doing is to be able to speak truth to power, and the questions and issues that this conference attempts to address are at the heart of public policy making as well as law reform. I'm delighted that Professor Kalantry has used both public policy as well as comparative law in addressing a very critical issue that has been confronting many countries in the world, including India, and I'm confident that some of the findings as well as her perspectives will help shape law and policy in India and in the United States. It is also useful to note that comparative law and research related to comparative law is one of the more difficult tasks to undertake. One has to have a profound sense of understanding of both the jurisdictions one is undertaking research, and should be mindful of the inherent challenges of any comparison that involve completely different jurisdictional contexts as well as legal and political cultures. That is the task that Professor Kalantry has undertaken in this book, and that makes this book special. It's also useful to mention that books like this have an opportunity for other researchers to identify issues that may be germane to both the democracies, United States and India, and also to recognize the complexity of legal norms and legal cultures in both societies. And I hope that it will inspire many of our faculty members and hopefully our students to be keenly observing the impact of law in both these societies. I would end by saying that it's a pleasant moment for us when we are doing this joint conference as well as the joint Human Rights Day lecture, that we continue to be engaged on these issues in a way that academic institutions ought to resist any form of dogmatic engagement. Today, more than ever, universities are witnessing a fair amount of resistance and unfortunately pluralism as a form of culture is slowly deteriorating in our country. This is an opportunity for us to embrace the pluralistic ideas that universities ought to be built upon, and the kind of dogmatic thinking that at times happens in universities need to be resisted through an informed understanding and promotion of these debates and discussions within the university campuses. I am confident that today's discussions as well as the book launch itself it will promote these ideas, engage people to think creatively, think critically, and engage in an analytical discourse that helps us understand these issues in a more nuanced manner. I also want to end by saying that it's a pleasure that we will be signing this MOU. I would like to take a moment to thank the Dean of the Cornell Law School, Professor Eduardo, who has spearheaded the collaborative effort that has culminated in the signing of the MOU today. He is not present with us, but he has sent his warm regards to all of us, and this will pave way for many more opportunities for our students. Jindal Global Law School and OP Jindal Global University is 8 years old. We are in the first decade of our evolution. As you know very well, when we began in a very modest manner with only 10 faculty members and 100 students in the year 2009, little did we know that these 8 years will help us evolve into an institution of global significance and excellence. Today, with over 3,600 students and over 300 full-time faculty members, we are poised to become one of the institutions of global excellence, not only in India and in the region, but even beyond. This could not have been possible but for the extraordinary support and vote of confidence that people like Professor Sital Kalantry had on us, and in our early phase. Her farsightedness, her vision, and her imagination helped us to build this relationship at an early stage of our evolution, and today this has withstood the test of time, and we are embarking on a new journey which I believe will have profound impact for the future of legal education as well as research in our country and beyond. I also want to take a moment to thank Honorable Ms.Justice Gita Mittal for her support to our institution in its early phase. You all know very well that the judiciary in general and society also in India is hugely skeptical of private institutions and private law schools and private universities. In the milieu in which there is so much of skepticism and pejorativeness associated with private law schools and private universities, it is again the leadership as well as farsightedness of Justice Gita Mittal that she supported our endeavor in our early foundations and helped us to grow over the years. I am grateful to her for her magnanimity and her graciousness for being part of this conference and indeed the book launch, and continue to inspire us for all what we are doing. Thank you and welcome to the conference.
A very good morning to all of you, and let me join Professor Rajkumar in welcoming you to this conference once again. You'll hear about the book from Professor Kalantry shortly. I'll just take a few minutes to introduce her to you. Professor Kalantry is clinical professor of law. She's the director of the International Human Rights Policy Advocacy Clinic, and she's also the co-director of the Migration and Human Rights Program at Cornell Law School. Professor Kalantry has published in the areas of women's rights, educational rights, in prestigious journals such as Human Rights Quarterly, National Law Journal, Stanford Journal of International Law, the Nordic Journal of Human Rights, among others. In addition to these, as Professor Rajkumar said, she's also been a Fulbright scholar, and she's been a longtime friend of the Jindal Global University. I'll invite Professor Kalantry to talk about her book. Releasing the book, may I request Honorable Ms.Justice Gita Mittal to release the book.
Thank you very much, everybody. I really appreciate it. Justice Mittal, Vice Chancellor Kumar, respected panelists, guests, all these wonderful students, I'm so grateful for your presence here. Justice Mittal's dedication to ensuring justice for women and all litigants before her has been inspiring for me for over a decade since I've known her. I've also been privileged to watch Vice Chancellor Raj Kumar revolutionize legal education in India. In today's global world, both disputes and transactions occur without respect of national boundaries. The joint program that we're inaugurating today recognizes that to be successful lawyers in today's world, you have to practice without borders. This multi-jurisdictional program trains lawyers to succeed in the global world we're living in today. I appreciate the time and effort taken by the panelists to engage with the book. I have much to learn from their expertise, and I'm again thankful for all of the constant support from mentors, colleagues, and friends. The book is about the impact of global migration on women's rights. So people are increasingly migrating around the world. I would guess that the majority of the people in this room have a sibling, cousin, or other relative who has moved to the United States. My parents migrated when I was young. Sometimes people like me are known as ABCDs, which are, for those of you who don't know, American-born confused Desi. And I was born in India, so that just makes me a CD, confused Desi. But in all seriousness, notwithstanding my American accent, I consider myself bicultural with one foot in both countries.
Speak good Hindi as well.
और अच्छी हिंदी भी बोलती हूँ. I inevitably bring a comparative lens to the study of India and the United States. The title of today's program is a transnational dialogue on gender-based sex selection, gender-biased sex selection. But some of you might be wondering, why do we need a transnational dialogue on this subject? So let me try to explain. Immigrants, when they move to the country of their destination, are sometimes believed to replicate practices that exist in their country of origin. Indians living in America, for example, are presumed to sex select for girls at the same rates as people living in India. In addition, in today's global world, snapshots of human rights violations and the consequences and causes of sex-selective abortion in India are packed into unnuanced media sound bites and instantaneously travel around the world. Some groups have utilized this distorted information about sex-selective abortion in India and China to limit women's rights in the United States. It is for this reason that I believe to understand and solve local problems, we need solutions that are developed from a global perspective. A dialogue across borders is necessary, therefore, to uphold women's rights within country borders. There is one thing that surprises people the most when I talk about this book, and it may surprise some of you here as well. It is the fact that 10 American state legislatures have adopted laws to make it illegal for a woman to terminate her pregnancy if her motive relates to the biological sex of the fetus. Moreover, in the last 5 years, more than 25 out of the 50 American states have introduced such bills. So unlike the United States, some issues are subject to state law. There's much more state regulation in the US than in India. One of the reasons that so few people are aware of this trend, even back in the United States, is because the major players in the reproductive rights movement have not made it their priority to fight these laws, despite the fact that they are actually harmful to women's rights, which I'll explain in a minute. The notable exception to this is the National Association of Asian Pacific American Women, NAPAWF, whose executive director, Sungyeon Choi-muro, is sitting back there, and she will be speaking later today. Unlike in India, there is no movement, in India, for example, there's no movement to repeal the Medical Termination of Pregnancy Act, but in the United States, a vocal and effective religious-based movement has been successful in limiting access to reproductive rights in American states. Calling themselves pro-life, the movement claims that the bans on sex selection are needed in the United States to prevent Indian Americans, as well as Chinese Americans, from discriminating against their female fetuses. While pro-choice people who normally support women's reproductive rights, and they hardly ever agree about anything with pro-life people, seem to have a Rawlsian overlapping consensus where they support these bans. In my research, I have found that elected members of state legislatures who claim to support women's rights have actually voted in favor of these prohibitions on sex selection. Now, the laws are harmful, I believe, in the United States because they restrict access to non-selective abortion, and as you'll see in a moment, they actually don't address any problem that exists in the United States. Some states require doctors to delay providing reproductive rights if they first require the doctor to ask every woman, not just Asian American women, if they know the sex of their fetus, and if the woman says yes, then they have to seek information about her medical records, creating unnecessary delay. Now, there's an injunction against that law, but that's an example of one. Asian American women could be profiled and assumed to be obtaining these kinds of abortions. So, and if the Supreme Court of the United States finds this law constitutional, the question hasn't reached the court, but a case is slowly making its way there. More reason-based bans, like disability selection, race selection, will be adopted, further narrowing reproductive rights. The firestorm of legislation began almost immediately after an article was published in 2008 by two professors, economics professors at Columbia University, in a preeminent multidisciplinary science journals. The authors compared the ratio of boys to girls of Asian American families, compared it to the ratio of boys to girls born to white American families at each birth parity. They obtained this data from the US 2000 census. The authors found that the sex ratio of second children of Chinese, Indian, and Korean American families that had one prior girl child is more male biased than the sex ratio of second children of white American families who had one prior girl child. For the third child, the ratio becomes even more male biased. The authors interpreted their findings to suggest, and they wrote this actually in their article, and I quote it, that the magnitude of the deviations for second and third children of Chinese, Indian, and Korean Americans is comparable to that documented in India, China, and South Korea. This sentence found its way into numerous media stories, both fake media and real media, as our President Trump calls it. To put it another way, both liberal and conservative media carried stories suggesting that there is now a sex selection crisis among Indians in the United States. But this interpretation of their statistics is actually wrong. Although the economics professors never reported the number in the article, from simple calculation, we can determine that even if they're right, there are about maybe 2,500 missing Indian and Chinese girls in the United States, all over the United States at that time period. By way of comparison, as some of you know, people suggest that there are over 60 million missing girls just in India. Working with the National Association for Asian Pacific American Women, NAPAWF, and several economists, we examined newer demographic data from the American Community Survey of 2008 and 2012. We found something that had never been seen in any prior study, which is that a fraction of these Asian Americans that have two boy children may actually be selecting in favor of a girl child. So their third child, when they have one and two boy children, their second and third child's sex ratio appears to be more girl biased. So now there's gender selection in favor of girls. And again, this is a very tiny number in the thousands. It's not all Asian Americans, it's not even close to that. And also confirming prior studies, we also found the same issue, which is that when there's a girl child, there's also the second and third child have the sex ratios are more male biased. So of course this data tells us nothing about the motives of why people are doing it, nor does it tell us what method they are utilizing. In the United States, it is legal, and clinics regularly advertise gender selection on pre-implantation basis, so sperm sorting and IVF are legal to use for gender selection. So one plausible explanation that I believe is that the small number of these people, as these families, are acting to balance their families. They want one girl and one boy. I mean, we may not agree with that. We may think that's problematic for a host of reasons, which I get into in my book. But that doesn't necessarily mean that they act out of a daughter aversion. But this narrative does not prevail in the United States, and instead misinterpretations of data fueled by stereotypes about Indians living in the United States is influencing legislation all around the United States. To evaluate bans on sex selection, I suggest, and other things like veiling and other practices, right? So I'm focusing on sex selection, but my idea and should apply to all these practices that are considered harmful in countries of destination. So France bans veiling based on the same decontextualized information. But I suggest we need to take a comparative look at the historical, political, and social context where the practice initially emerged. Why does the practice raise concern for women's equality in India? Do the same concerns and factors exist in the country of destination of the migrant? So let me illustrate by these two cases. Case one of an Indian woman living in India takes steps to have a boy after she has a girl. In the case two, a woman of Indian descent living in the United States takes steps to have a boy after she has a girl. In both cases, if one believes in the bodily autonomy and privacy rights of women, and hopefully this new privacy judgment that you have will create a basis to ground reproductive rights in the Constitution as opposed to in the statute. So if we believe in that, then we think that it shouldn't be, either of these two women should not be restricted from acting on whatever their preferences may be. But however, the first scenario of the woman in India raises different concerns for feminists than the second one. Social institutions such as dowry, patriarchal forms of marriage, and fewer economic opportunities for girls are some reasons that some families in India, in some places, want to have at least one boy child. So that's how sort of I interpret the data, is that they want at least one child, not necessarily that they want no girls. Maybe some want no girls, but the majority, I think, want at least one boy child. So when families play into this tradition, they further perpetuate and reinforce these customs. In the case of the immigrant woman in the United States, the context in which the act occurs is different. She will not likely be required to pay money for the groom to marry her daughter off. She can rely on Social Security and other state support rather than relying solely on her son for economic support. There's no prevailing custom that daughters can't provide economic support to their families. And large numbers of people are not systematically selecting in favor of boys. I believe that restrictions on women's autonomy, however, may be appropriate in light of the consequences of sex selection. Emerging studies on India, many of which appear in a book edited by a speaker in one of the next panels, Professor Kaur, suggest that violence against women is associated with the surplus of men. So in other words, some of these studies by economists have shown, and anthropologists and sociologists, that harassment of women and domestic violence are higher in districts where there is a greater surplus of men. Feminists are essentially caught between a rock and a hard place in regard to sex selection. We want to preserve women's reproductive rights, yet at the same time, some people object to the way in which sex selection is practiced in certain societies. Some feminists take positions in their advocacy that unintentionally undermines women's reproductive rights. The transnational feminist approach I propose, and this is one of the reasons that I wanted to have this conversation in India and get people's reactions to it, sort of tries to find a way out of that bind by focusing on what consequences the actions of many women are having on the women living in society. A focus on consequences of this practice rather than just causes, which is also important, but also opens up the possibility of different solutions. If we think the problem is the male surplus, then we want to increase the number of women and girls in society. And there are ways to do this, such as possibly, and I'm just suggesting and getting people's reflection on this, is to allow gender selection in favor of girls pre-implantation, like in the US, sperm sorting or IVF. This won't equalize sex ratios. It will move in the right direction. There may very well be some parents who want to have a girl but don't take the effort to do so. So, to conclude, immigrants' women's rights implicate concerns that can't be solved just by international law or domestic law, developed in isolation from transnational practice. The growing field of transnational law fills the gap between a purely international legal approach and a domestic approach to lawmaking. And there is no better day today, on International Human Rights Day, for this transnational dialogue, to stand where we all stand together to uphold the rights of women and other marginalized groups around the world. Thank you very much.
Thank you, Professor Sital. Without much ado, I'd like to invite Hon'ble Justice Gita Mittal to deliver the inaugural address.
Professor Dr. C. Rajkumar, Sital, my dear friend, and someone from whom I've learned so much, Professor Mandal, Professor Devyai, learned academicians in the audience, Justice Kannan, who's sitting at the end of the room, another person from whom I've learned so much, and all my young friends in the audience. Sital has almost summed up everything I had to say. But I want to take this conversation into another plane to point out, what we talk in this country from a very different perspective. And as I've been telling her for the last 3 days, that her book has made me look at my very well established notions and principles from a completely different perspective. And I would like all of you to look at something which began as something very ordinary event in the life of an academician, and which took her into examination of an issue which is extremely relevant. Sital's engagement with the issues commenced when she was asked to moderate a film discussion at the University of Chicago titled "It's a Girl, the Three Deadliest Words." This film told a narrow story about sex selection in India. Her discomfort with the film and the general acceptance of its message by the people with whom Sital watched the film led her into ascertaining the credits for the film. Her discovery was that the director worked for an organization that made gruesome anti-abortion videos, and funding for the film was sourced to such organizations. Very typical of the arguments against abortion and for abortion in the United States of America. Sital tracks the legislative ban on sex-selective abortions and points out that the screening of the bill was happening in the U.S. legislature and the screening of the film was happening when a bill for such ban was pending in the United States House of Representatives. In the introduction to the book, I find that it is pointed out that the bill's preamble stated that its purpose is to stop the widespread practice of abortions of female fetuses by Indian and Chinese people living in the United States. Bills like this were also sweeping across state legislatures. Sital has just pointed out to us, by 2016, half of all state legislatures in the United States had voted on bans on sex-selective abortions, purportedly to address the behavior of Asian Americans. 7 states enacted the bans during this wave of legislative activity. 2 states had adopted them decades ago. Americans went to India and China, made a film depicting what was called the culture of son preference and violence against women, and brought it back to the United States to support the claims that Asian Americans sex select and to lobby for laws that burden the reproductive rights of all American women. The rub of it is that they are convincing pro-choice feminists that the ban promotes women equalities, clearly utilizing the shield of the equality argument to enact legislations which actually impede women's rights and ensures that they are adversely affected, especially their agency to so far as reproductive rights are concerned. Moreover, anti-abortion legislators and movement actors deceptively used advocates concerned about women's equalities in other countries to further restrictions on reproductive rights. So Sital actually points out that the film which she went, It's a Girl, and captioned It's a Girl, the 3 deadliest words, was being used to promote such advocacy to encourage prohibitions against women's agency so far as their reproductive rights is concerned. So what happened then? Sital then teamed up with experts to study the issue, further investigating the issue from empirical, comparative, legal and medical perspectives with experts. They released their report in 2014 and documented the empirical findings, disproving other misrepresentations made by supporters of sex-selective abortion bans in the United States. Since the report was released, this is very important, and this is what all of you who are students of law and social-related issues, since the report was released, no bill banning sex-selective abortion has been adopted by any state in the United States except the state of Indiana. However, a federal judge in Indiana has blocked the enforcement of the Indiana law. This book builds on Sital's collaborative as well as her individual work on sex selection. And I can very candidly admit here that reading, I have had this book for some time, but I actually went through it because I was being given this opportunity and being asked to speak here on it. But it has completely transformed a lot of my notions on sex selection, the reasons, the basis, and also how we should look at it. Certainly, if I am confronted with an issue which raises aspects of sex selection and women's reproductive rights, I will be much guided by the work that Sital has undertaken in this book. So the raison d'etre, so far as India is concerned, of the decision not to allow disclosure of the sex of the fetus to the parents prior to birth of the child has ostensibly been ensuring the safety of the unborn child. And it was, we must with regret acknowledge, prompted by the unfortunate premise of female feticide pervading some cultures. It has also been prompted by the belief that such bans promote women's equality. Sital's book, An Argument, and the empirical data she places points out and highlights what a complete fallacy this is. Sital Kalantry's book addresses more than one issue, resting on a multidisciplinary examination of such beliefs, resting on an intensive empirical study regarding reproductive practices of immigrant women, more specifically sex-selective measures being adopted by the migrant Indian and Chinese community in the US, and the perceived necessity of the US administration to have to curb the same. Sital has also analyzed with penetrative insight the results of the data on the Indian and Chinese psyche erroneously perceived to be going to any lengths to ensure that a male child is born. It therefore addresses important issues about human rights of women relating to practices undertaken by immigrants in their country of destination. While the book is subtitled Sex-Selective Abortion Laws in the United States and India, it does not rest in dealing with abortion, which is considered a post-conception malaise. It also addresses the issue of preconception sex selection and psychoanalyzes the behavior of the average migrant Asians in this broad context. It has addressed the causes behind these practices and suggests remedial measures. At the same time, it also suggests hearteningly that there is a subtle change and there's a definite change in the practice and the mentality, at least of the average Asian American, who is willing to welcome into the world one as the other. and it does not now discriminate between a female child or the male child, and is willing to welcome into the world one as the other. In India, however, the book suggests we will have to examine it from a different perspective in order to inculcate a similar approach. So, how does the book look at the issues which it has raised? It has adopted a multidisciplinary approach to sex selection. Through her book, the author has pointed out that much of the earlier work on the subject has been undertaken only in specific geographies such as India or China, or in using only one methodology such as the feminist theory, whereas through this book, effort has been made to examine sex selection globally and through multidisciplinary lenses. Sital points out that this approach may especially profit judges who exercise jurisdictions over many different countries, such as the European Courts of Human Rights. And I may point out that given the current situation the world over, the extent of migration that is taking place, even not only inter-country, but also within the country, there is so much displacement in so many jurisdictions that this book is extremely relevant and has come at a most opportune time. Meaning of sex, then Sital examines what is the meaning of sex selection and family balancing. The author has described sex selection importantly to mean the process whereby people intervene with nature in an attempt to give birth of a child of their desired sex. In describing the act as sex selection, Sital Kalantry has innovatively sought to depart from the more conventionally used term gender selection, arguing that gender is both a biological and a sociological construct. She has advocated that some families who engage in sex selection do so to achieve gender variety in their families, which practice she refers to as family balancing. I don't think any of us, or at least most of us in this room, would have examined sex selection from the perspective of a practice to ensure family balancing. Sital has also incorporated a whole chapter to contextualize the reason and basis for this practice. It is contemplated that partly the reasons for feminists in India objecting to sex selection against girls is because they believe it occurs as a result of societal institutions. While this may be true that the practices are discriminatory against women in India, but that may not essentially be true for United States. While quoting her own examples, the author has argued that the context in which things are perceived in India may be entirely different from its perception in the United States. Many of the factors that define sex selection as discriminatory in India do not even exist in the United States. And she has very quickly enumerated the 4 of them, but I will dwell on it a little longer. Sital has firstly argued and pointed out that the practice of dowry causes people to prefer sons, but this practice is not common in the United States, even among the immigrants, where the cost of marriage itself is often shared. Secondly, in India, parents would like to have at least one son because they would rely on their sons for support in their old age. This is attributable to a lack of a national healthcare system in India, which is not true for the United States. So if the state is going to look after you, you do not have to rely on your sons for looking after you in your old age. Thirdly, the cultural practice in India is the patrilocal system, where the daughter leaves her parental home and shifts to her matrimonial home after marriage. The author places data in support that in only 0.7% cases in the United States, the household comprised of a parent-in-law, a son-in-law, or a daughter-in-law. In other words, nuclear families by and large. Finally, although in theory succession laws in India allow for inheritance by daughters, that does not happen practically, as parents or siblings pressurize daughters and sisters to relinquish their rights. This kind of pressure does not exist in the United States. Therefore, the motivations for sex selection seen to be discriminatory in India are generally not present in the United States. Sital clarifies that she does not suggest that it is appropriate to sex select, but simply endeavors to draw a distinction of the practice in two different countries. And these arguments have been dwelt on in several places in the book to encourage the thought that legislative practices or prohibitions may necessarily not be necessary or the required motivation, or that they would result in the end or the objective for which is the basis of the such legislations. The book has a very interesting chapter wherein they have considered balancing burdens on reproductive rights and harm to women and girls. Sex selective abortion statutes burden the legal right to choose, and I don't think there would be anybody in this room who would disagree. They will potentially limit abortion access to all women, these statutes, even those seeking non-selective abortions, particularly Asian American women. The author tenders that unlike in India, sex selection in America is not widely practiced, and the consequences of the practice do not harm women and girls in the American society. In balancing the burdens placed by the sex selective abortion bans on women's reproductive rights against the actual harm to women and girls, it is clear that the benefits of the bans do not outweigh their costs and do no more than impinging on women's rights. Interestingly, Sital has also intensively examined the constitutionality of the sex selective abortion statutes, emphasizing the aspect of the right to choose. The US Supreme Court's recognition in the whole women's health case to the effect that justification for the Texas prohibitory statute was nothing more than a fig leaf to restrict women's access to abortion has been used by Sital to advocate that the sex selective abortion bans should be viewed the same way. So let us see which way the US Supreme Court rules as and when this issue is raised. So to conclude, the author draws a curtain, leaving the readers with even more challenging thoughts to ponder upon. She says that under the extreme version of cultural relativism, human rights are subject to religious and cultural values in society. So therefore, the qualification for a right to be recognized as a human right would be for it to be in consonance with the cultural values. I think this is a very, very important statement which every student or teacher and teacher-in-law needs to understand and emphasize. As a corollary, the legal approaches which emerge between universalism and cultural relativism would be that a practice which would contravene women's equality in one country may not have the same effect in another. The author therefore builds on the insights of transnational law as a methodology to evaluate one specific issue, cross-border practices. She authoritatively states that regulations on cross-border practice should be enacted only after considering and comparing the context from where the practice originally emerges and the context where such regulation is being considered. Sital uses sex selective abortion bans in the United States to elucidate and develop a transnational legal feminist methodology. She suggests that it is important for policymakers in migrant receiving countries to understand the actual scope of practice and motives of those who engage in it, instead of decontextualizing by assuming that the migrants would undertake the same practice with the same motives as their country of origin. It is stated that it may be an erroneous assumption that a practice undertaken by people in a foreign country will have the same negative consequences when undertaken in their own country. The author proposes a comparative examination of the societal context, individual motives, and other factors which contribute to the occurrence of cross-border practices in both contexts. Sital has also argued and emphatically that the reproductive rights of women should only be burdened if it can be proved that the way in which sex selection is being practiced by a large number of women in any particular country negatively impacts women and girls in that country. That is the country of their destination in this case. Therefore, she has advocated that while the ban in India, which we have imposed in 1994, may be justified considering the increasing violence against women, the same does not apply for the United States. Through her book, Sital has made a compelling case for revisiting the ban enunciated in the United States so far as a sex-selective abortion is concerned. According to the author, the ban emanates from a presumption that the Asian American community may only be interested in abortion of female fetuses. The ban has failed to note that as a result, the reproductive rights of all American women are being curtailed. The book carefully highlights the modus which lobbyists employ, such as making movies which portray the East in extremely poor light and affix domestic violence as the only cause of sex-selective abortion. While the United States government may be free to go ahead and install a ban as a matter of policy, but basing its conclusions on incomplete facts to further the reproductive restrictions may be completely unjustified. The reasons for abortion may not be sex selection, but based on other factors such as effects on health, physical or mental, or as a matter of family planning. Personally, after reading the book, a Pandora's box has opened in my own mind that traditional theory and international human rights law has failed to recognize the right to choice of agency of a woman as a tenet of her basic human rights, and more importantly, the need to contextualize statutory prohibitions in the context of society as well as developments of technology, health, society, and which movements within the community and society may mandate. Ladies and gentlemen, India for that matter, China, China today is obviously not India or China was as it was 2.5 decades ago when the PNDT Act in India had to be enacted. It has progressed to a point where we, one and all, celebrate with equal pride the achievements of a girl child as those of a boy child. I may quote a simple example from my own fraternity manifesting the reality of increasing recognition of ensuring equality in judicial appointments. Of 4 advocates who have recently been elevated as judges in Delhi High Court, 2 were women. Even more significantly, out of 6 judges appointed in the Madras High Court last week, 4 were women. More and more we see in the subordinate judiciary where the entry point is based on a written examination, 50 to 60% women candidates are proving successful. So clearly, ladies and gentlemen, and I speak here not just as a woman, but as a representative of all right-thinking persons, while it is high time to shed our shackles and shed away not only our moth-eaten predilections towards the male child, but for the world to rid itself of the prejudices and biases towards the values, beliefs, and expectations in which Asians react and conduct themselves. A reading of Sital Kalantry's exhaustively researched and painstakingly assimilated book, I am confident would go a long way in reaching such end, provided of course that we are willing to dispassionately effect the data and the analysis that the book provides, examine it, assimilate it, and evaluate the results. The book is not bedtime reading. It addresses an issue which today is of perennial significance with elaborate data, facts, and figures, and calls on us to accept and analyze them. If from our busy schedules we are able to take out a little time to do so, I assure all of you, my friends, that the result would be highly rewarding. Thank you.
Thank you, Justice Mittal. I'd like to take this opportunity to invite our Honorable Registrar, Professor Murthy, to also come on stage. What I'd like to say is the Dean of the Cornell Law School has already signed the MOU, and now Professor Murthy and Professor Rajkumar would sign the MOU on behalf of Jindal University and hand over 2 copies of the same to Professor Kalantry.
Gaurav.
One word to say thank you so much for doing this. And just so you know, I mean, this is an incredible program where students can receive from Jindal Law School in 6 years a BA, an LLB, and an American law degree, which normally would take 8 years to receive. So we don't have this agreement with any other law school in India. We don't have this agreement with any other law school in Asia. We don't have this agreement with any other law school in the world except for a handful in Europe. And I think it recognizes where Jindal is and how we value the education that's happening here and being provided here, and the great students that are coming out from this school, like all of you. And I encourage all of you to apply and come and be trained here. We have, and as I mentioned before, the benefits again are you can work anywhere in the world, around the world, and in today's world, that's what is happening and what is exciting about the practice where things are in the practice where you're coming to be graduates at this time. So thank you, Raj, for entering into this to us, and we're honored to be a partner of Jindal Law School.
I'd like to take this opportunity to thank Justice Mittal and Professor Kalantry. I'd request Professor Murthy and Professor Rajkumar to kind of, as a token of appreciation, give a few mementos to our eminent guests. Professor Murthy. So with that, we close the inaugural session.